At some point during the course, we'll announce a 5-digit code to ensure that you guys are all still here. Make sure you write down the 5-digit code on your affirmation sheet. If you did not receive the affirmation or the evaluation sheet this morning, you should be able to find a copy in the Files tab within this webinar. Also, we will be having a copy in the chat as well, or feel free to send me an email for a copy. I will also be putting my email in the chat as well. The certificates of attendance for this course will be issued as soon as possible, but please give us a few days. Note to all the attendees, please remember to forward your completed evaluation form and affirmation sheet at the end of the webinar. We will email you the certificate as soon as they become available. But thank you guys so much again. And without further ado, here's Margaret Ling.
Thank you so much, Ashley. We are so excited. I can't even explain to be here today. For many of you who do not know me, my name is Margaret Ling. I'm the New York State Agency Underwriting Counsel at AmTrust Title Insurance Company. We are a national underwriter, and I want to thank my AmTrust team, and I will cite them specifically in a moment, for supporting me in this journey to get this to a CLE. I want to thank Edgar Chen, who's Special Policy Advisor at NAPABA, that's the National Asian Pacific American Bar Association. We've worked over a year on the research with the support of my National Underwriter Counsel, Michael Smith at AmTrust, and James Tarlton, our Regional Counsel. We've started thinking about this last June as everything hit the courts and hit each state. We tracked it, and here we are today. I want to thank the audience for coming at 11 o'clock in the morning. I have people from Honolulu, our panelists from California, my staff from AmTrust, I won't say where they are, but they are Pacific Coast time, for joining us on such an important topic. We have attorneys, realtors, title underwriters, title agents, local and national regions, people that are interested in this particular topic. And we're going to do our best to put it into 75 minutes to give you a basic idea of what all of this means, and obviously do continuing CLEs from this program on. There'll be more. Okay. So before I forget, I want to thank my AmTrust family for sponsoring and supporting this. Specifically Ashley Rodriguez and Victor Archilla, my marketing team, that's there for me every minute up until the taping of this and on to later. And thank the president and my general counsel, James Sanasulis, for attending today and being very supportive of all the programming that I do. And again, Michael Smith, our SVP and National Underwriter Counsel, and James Tarlton, our regional counsel from the Southeast, who will also be on the panel today. I want to also explain that, as Ashley said, all of you that got the link got an acknowledgement form, which will be filled with a code that she will announce at the end of the program. You cannot leave until you get the code, and you will get your CLE certificate sent to you after. Please fill out the evaluation sheets. I read them. All right. Our materials are in that file. A lot of really good materials. And Edgar and the panelists, we've really tried to track up to date. You'll see some of the latest and the greatest that we will be talking about on this topic. It is being recorded, so I know a lot of people couldn't make it, and just contact me if you want to get the recording. And here's my contact information. It's margaret.ling@amtrustgroup.com. Okay. Let's go on and see who's with us today. So with us today, all right, is Edgar Chen, Esquire, Special Policy Advisor for NAPABA. That's the National Asian Pacific American Bar Association. I want to thank Rahat Babar and Priya Puradan, the Executive Director, for supporting and attending today. They're in the house with us today. I wanted to also thank Hope Atuel, who's the CEO and Executive Director of the Asian Real Estate Association of America. I've been on several boards and a member for over 20 years. And it means so much that they are also supporting this legal CLE and sharing what's so important to the realtors regarding this legislation. Also on our panel is Bethany Lee, Esquire, Legal Director, and now I'm proud to announce the Executive Director of what we call ALDEF in New York, the Asian American Legal Defense and Education Fund. You will see how important they have been in advocating and in lawsuits and in really pushing the issues forward on these national alien laws. I'm speaking, and then Allan Lowe Esquire, partner from San Francisco, Parkins Coie, will talk about the investment development and how that's affected banking. And last but not least, James Tarlton Esquire, Regional Underwriting Counsel Southeast for AmTrust Title Insurance Company. And we are just thrilled. This panel has had many meetings, and even up until last night, Edgar had some important news that he wants to share with us today. And without further ado, let's get us going. We will hopefully be done. It's 11:06. We'll get everybody out of school by 12:15. We try to have everybody do everything on a timely basis. But if we're just running a little bit over, please bear with us. There's just so much to get out there that we really want to share with you. On that note, welcome, Edgar. I'm happy to see you here today.
Hi, good morning, everyone. Thank you, Margaret, for that wonderful introduction. Again, I'm Edgar Chen, Special Policy Advisor for the National Asian Pacific American Bar Association, or NAPABA. I'm so privileged to moderate this panel of leading experts who will help us examine the issue of alien land laws from so many crucial various angles. Alien land laws implicate so many different legal and economic issues, from the Fair Housing Act to equal protection, immigration law, foreign policy, U.S.-China relations, federal preemption, title underwriting, the real estate market, and the investment climate. The goal of today's CLE webinar, generously brought to you by AmTrust, will be to help you issue spot a couple of these facets here. And we were not going to be able to get into too much depth on any particular topic, which could be its own CLE. But I do want to say, as Margaret mentioned, the timing of this webinar is very prescient. Right now on the Hill this week down in Washington, D.C. is so-called China Week. There's a raft of legislation designed to counteract, China's purported influence in the United States, including a bill called H.R. 9456, which requires that the Department of Agriculture report to CFIUS, the Committee on Foreign Investment in the U.S., anytime there's an agricultural land purchase with a Chinese buyer. Okay, so that would essentially create a huge registry of, of folks, notwithstanding that there's no evidence that they're a state actor or an agent or a government official or anything like that. It's just anyone from China. And so that's the climate that we're operating in. That's some of the context that's going on the Hill as we do this webinar today. So I'm going to get into a little bit of the history and context very quickly before hearing from the rest of our panelists. First, the resurgence of states imposing restrictions on purchase of real estate has struck a painful nerve in the Asian American community. And that's because these laws are coming back at a time right on the heels of the pandemic, where we saw this spike in anti-Asian hate throughout the country. And historically, these laws we thought were sort of dead and gone more than a half century ago, because it was laws like the Chinese Exclusion Act, the Page Act, other laws that specifically targeted Asian immigrants at the beginning of the 20th century that we thought were really confined to history books. California first enacted its alien land law in 1913. Then in 1920 added limitations on leaseholding. We saw similar laws in Washington State, Oregon, Idaho, Montana, Arizona, New Mexico, and in other places. In 1947, the Supreme Court actually held that California's alien land law violated the equal protection rights of a Japanese American child citizen who held title to his father's farm on behalf of his father, who's a Japanese American. That's the Oyama case. And so one of the first precedents we have here at the Supreme Court that recognize that their rights are being violated is a title case. So that's appropriate to note. California's alien land law was finally overturned in 1952 at the state Supreme Court in a case called Seifuji, which held that law violated the 14th Amendment. We're going to hear a lot today about Florida's alien land law. That's because of litigation that's ongoing there right now. Florida's newly enacted ban on Chinese and other purchasers of real estate is actually an ironic twist to a saga that only 5 years ago saw Florida as the last state in the entire country to actually strike discriminatory alien land laws from its own constitution, which had been on the books since 1926. All right, so very quickly, that's a little bit of historical background. I want to talk very briefly about some of the characteristics of what these alien land laws look like. First, I'll talk about the numbers. According to the Committee of 100, which has been tracking a lot of these restrictions on foreign ownership, this year alone, as of summer of 2024, there were a reported 151 bills restricting property ownership by foreign entities across 32 states. We think about a dozen of them have passed. About half of those specifically prohibit Chinese citizens from purchasing or owning some form of property. Those laws have been passed in Georgia, Indiana, Nebraska, Oklahoma, South Dakota, and Tennessee. Last year, 2023, we saw a whopping 241 bills restricting foreign ownership across about 36 states. So what do these bills actually look like? Let's talk about the affected parties. Some of these bills just have blanket restrictions on any sort of foreign ownership, irrespective of country of origins. A lot of these bills focus on a group of countries, 7 that were designated by the Commerce Secretary as foreign adversaries. That is China, Russia, North Korea, Iran, Cuba, Venezuela, and Syria was on that list at one time. A lot of these focus on this, what we call Core 4, which is China, North Korea, Iran, and Russia. Some bills have purported to restrict property ownership just for Chinese citizens. It's standalone bills that say if you're from China, you can't buy property. That was Alabama's SB 379. And there are some exceptions in these bills for U.S. citizens, dual nationals, or green card holders, but that will vary by state. The types of restrictions involved, some bills target residential property. Some are only focused on agricultural land, farmland. A common sort of tone there is that food security is national security, and we do not want to sell farmland to foreign adversaries. Many of these bills include restrictions based on geographic radii within 10 miles of critical infrastructure or military bases, within 20 miles, within 5 miles, within 1 mile. And that's one of the most ambiguous and concerning problems, I think, for the market, and we'll talk about that later. And some even prevent leaseholding by the same groups of folks. One thing that has been apparent in these bills, and this applies in the Florida bill, SB 264, is that it treats with no distinction, provides the same treatment to government entities, political party members. So if you're a Chinese Communist Party member or a Chinese government official, or if you are an ordinary unaffiliated person with no links to those organizations, you're treated the same way under Florida law and in many other jurisdictions as well. And with that, I want to ask Bethany Lee from ALDEF to talk about a little bit more about that Florida legislation here. Bethany, tell us about some of the constitutional infirmities that you've seen characterized in alien land law, such as SB 264 in Florida, where you're involved in litigation on behalf of some plaintiffs down there. If you can say a little bit more about that and a little bit more about the plaintiffs.
Sure. Thanks so much, Edgar. I just to say, I'm Bethany Lee. I'm the legal director and the incoming executive director at ALDEF, and I'm so happy to be here today to answer the question directly. Plaintiffs asserted that Florida, the new Florida alien land law, SB 264, violates the 14th Amendment's equal protection and due process clauses, as well as the Fair Housing Act and the Supremacy Clause. More specifically, we say the law facially classifies people based on race, national origin, and alienage. And I can talk through a little bit of where that case is now. But we step back for just a second, and I want to think a little bit about the framing, right? And what does it mean to be talking about land? What does it symbolize? What's the value of land, right? Why are we fighting the same version of the same thing, essentially, that Asian Americans fought already 100 years ago? And I'm going to kind of give you a somewhat parallel example that I've been reading a little bit more about and kind of learning more recently, that even at the height of Black farmland ownership in 1910, very few Black farmers owned land. And if you look at the stats now, less than 1% of farmland is owned by Black farmers. You contrast that with 95% of the farmland owned by white farmers. And so there's obvious wealth impacts and generational wealth impacts that we could talk about for a long time. But for our purposes too, and across the board, when we look cross-racially, the broader message really is this isn't your home and you're not welcome here, right? So to think about land in that context, and I know there's real estate agents and it kind of is on this call, and it kind of hits home a little bit differently, right? Um, so as Edgar mentioned, in the past couple of years, there's been more than 30 state legislatures that have contemplated these bills, which is an astounding number, right? Because one of the professors that we work with on the Florida alien land law case, he likes to make the point that he was working on trying to remove old language from state constitutions, more not as an academic exercise, but in some sense as like a symbolic exercise, right? And so it's astonishing to him that suddenly we're going to him for his expertise on these old, historical, outdated, racist alien land law cases because they are literally from 100 years ago. The Florida law, SB 264, applies to people who aren't U.S. citizens or permanent residents and whose so-called domicile or permanent home is in China. They're prohibited from purchasing property, including homes in Florida, very narrow exceptions. And there's terms like not being able to buy within certain miles of so-called critical infrastructure or military installations. These are terms that are very vaguely defined in the law, but there are at least 21 large military bases in Florida, many of them within 5 miles of cities like Orlando, Miami, Tampa, which put many major residential and economically important areas completely off limits to people who are barred from this law from purchasing property, right? So when we're talking a little bit about the impacts. The Florida law also has a similar but less restrictive rule that applies to immigrants from Cuba, Venezuela, Iran, North Korea, Russia, and Syria. But the law singles out people from China for especially draconian restrictions and much harsher criminal penalties if they violate the law, including third-degree felony convictions. There's also a registration requirement for Chinese immigrants who already own land that harken back to special registration and other xenophobic means of kind of addressing national security concerns. To give you a sense of the posture of the case, plaintiff sued in the District Court of the Northern District of Florida. So we had a good time in Tallahassee for those of you who are there or know of the city. And as I mentioned, we asserted a variety of constitutional claims as well as violations of the Fair Housing Act. The district court denied the plaintiff's preliminary injunction motion. The court said that the law doesn't facially classify based on national origin or race. And it rejected the plaintiff's argument that domicile is proxy for national origin. It said basically that would mean that, actually this law would apply to any person who's domiciled in China. It doesn't necessarily mean that they have to be of Chinese descent just because they're domiciled in China. The first time, and I never thought I'd ever have to put into a brief that 99.9% of people in China are in fact Chinese. The law does also facially classify based on alienage, but the district court relies on terrace in a line of discredited cases that Edgar had referenced, which we'll talk about a little bit more. Again, cases from 100 years ago, right? So think about what that means historically and the context for those cases. And so on appeal, the 11th Circuit Motions Panel held that plaintiffs are likely to succeed on the preemption argument. This is with respect to Florida's alien land law, and they granted an injunction pending appeal as to 2 of our plaintiffs. Just a note, for those attorneys in the room, you should check out the concurrence, and maybe those legal nerds who aren't attorneys, because it's actually great. It addresses the other 2 arguments in a just really strong way, even if it's not binding at all. We had the merits hearing in April of 2024, and we are, in the middle of waiting to see what the decision from that is. Let me know if you want me to get into the legal arguments a little bit more to talk through preemption and the Equal Protection Clause.
Sure. Actually, before you say that, can you say a little bit more about who the plaintiffs are?
Sure. Yes.
How many of them are there, and what's their sort of situation? How did they, how have they been harmed by SB 264?
We have a few plaintiffs who are citizens of China. Some of them have been in Florida for many years, working in universities. Some of them are students, and some had actually purchased, intended to purchase property or purchase property before this law had passed, or in the middle of different transactions. We also have a plaintiff that is a commercial real estate firm that, has calculated and thought through what kind of client and money loss there's been as the result of SB 264. And so, I think there are obvious, especially for many of the realtors in the room, many obvious impacts when you talk about the types of restrictions that are being placed on people here. And in fact, we talked to not just realtors who deal with Chinese citizens, but also people from some of the other so-called countries of concern that the law addresses. And there were similar economic concerns that were addressed. But I also think that it's worth thinking through some of the indirect impacts, right? I can't forget a story that, we hadn't even brought the case yet, or maybe we had just sued. And before I was told that a commercial real estate firm that had leased a property, so this is totally not covered by the law, right? But a commercial real estate firm that had leased a property for its business, Chinese people, they were asked by the commercial landlord to vacate the premises before July 1st. The lease was not renewed. That's something that's just not contemplated by SB 264 at all, but gives you a sense of some of the, broader impact of the fear, the chilling effect that happens as a result.
And it sounds like the plaintiffs here are here lawfully. They're lawfully present. They're working. They're contributing to Florida's economy and have tried to make a home here. And a federal law, immigration law, recognizes their right to be here and to work, and yet the state, I guess, is saying that they can't put down roots.
Yeah, so the plaintiffs have been in Florida, worked in Florida for years, lived in Florida for years, and as a result, and have sought to be home in Florida while they are currently living and working here. And SB 264 essentially prohibits that, both symbolically and in some sense effectively.
Can you say more? So basically, you stated that the 11th Circuit basically has enjoined SB 264, but you said only on federal preemption grounds. Can you say a little bit more about what's going on there?
Yeah, let me talk a little bit about preemption and try to break that down for people. It's the Constitution's Supremacy Clause that provides a foundation for the doctrine of federal preemption of state law. Basically, it means that, right, federal law wins over state law. And so federal law may supersede state law as a matter of so-called conflict preemption, where the state law is an obstacle to the accomplishment of federal objectives, or as a matter of so-called field preemption, where states attempt to regulate an area where there's sufficiently dominant federal interest, right? And so SB 264, Florida's new alien land law, is in conflict with a 2018 federal law, which is called the Foreign Investment Risk Review Modernization Act, or FIRMA. This is the argument that the 11th Circuit recently held plaintiffs were likely to succeed on. And so to give kind of a little historical background, in 1975, President Ford established by executive order the Committee for Foreign Investment in the United States, so CFIUS, what Edgar had referenced earlier. And it's an interagency body that's responsible for reviewing certain foreign investments in the United States that have national security implications. And Congress has repeatedly expanded CFIUS's authority to review these foreign investments that might have national security implications. And in 2018, through FIRMA, Congress specifically empowered CFIUS to review certain real estate transactions that involve foreign persons or land that's in close proximity to, the words I used earlier, military installations and other properties with national security sensitivities. So first, under FIRMA, the federal government has adopted a case-by-case review process for evaluating transactions that might raise some national security concerns. And after reviewing, CFIUS can approve that transaction, impose some risk mitigating measures, or the president may bar the transaction altogether. FIRMA also deliberately exempts single housing units from national security review. So in enacting FIRMA, Congress actually was trying to strike a balance. It recognized that over-restricting property transactions could harm national security. It also emphasized that foreign investment benefits the United States. And so SB 264 is at odds with FIRMA, which instructs the president to consider the foreign affair implications of prohibiting any given property transaction that involves a foreign country.
Yeah, and I can see also how, let's say, hypothetically, if a Chinese company wanted to buy a commercial parcel of land in Florida and it went through CFIUS review and it was approved at the federal level, but barred under the state level, you have a conflict of laws, whereas you talked about in preemption, federal and state are going head to head in a clash. And as you noted, supremacy clause, the federal government wins that based on the Constitution. So I see how the 11th Circuit has decided that way. But in the minute we have left to talk about Chen v. Simpson, what are your thoughts on those equal protection grounds here? The 11th Circuit didn't address that in their in their first decision, but can you just say a little bit more about the equal protection side of the house?
I will tell you everything I think in 1 minute. I mean, just to kind of set the framework a little bit, under the Equal Protection Clause, government actions that intentionally discriminate are based on a suspect classification, such as here, nationality, are permissible only if they pass what's called a strict scrutiny test. And that requires showing that the action was narrowly tailored to serve a compelling state interest, right? And so the critical question here, as with all equal protection cases, is what's the level of scrutiny that's going to be used? That is where you're going to win or lose your case, right? And so the district court, what it does is that it relies on, among other things, a 100-year-old case, right, called Terrace v. Thompson, to say that so-called strict scrutiny doesn't apply. Essentially, the highest level of scrutiny that is applied to suspect categories, classifications, does not apply. It makes sense that one of the few cases they could find maybe somewhat on point was from 100 years ago, because these alien land laws that we were dealing with well before were from 100 years ago, right? In Terrace, the court had actually upheld a state-level alien land law in the face of an equal protection challenge by applying what is the equivalent of rational basis review, and which is kind of the opposite scale of strict scrutiny, right? And so, it's distinguishable on several grounds, but I mean, what I will say is, one thing to note is that the whole equal protection framework that has developed in modern times came well after Terrace was decided. And so, in some sense, the analysis that we're talking about when we talk about strict scrutiny and rational basis doesn't even, wasn't even contemplated in Terrace. And so the government makes arguments about this case not being officially overturned. What I learned recently, and I think it's worth us thinking about here, is that Plessy v. Ferguson also has not been explicitly overturned, but it's not a case that any government, any court would consider using when we talk about separate but equal, right? And so I think the fact that we're having these kinds of conversations and kind of delving more deeply into understanding these historical racist cases in our community is very helpful for thinking about how to be pushing back.
I think the Terrace v. Thompson case said it was okay for Washington State to enact its discriminatory land laws because Asian people, Japanese citizens, are not entitled to citizenship. Chinese Malays are not, but it actually specifically said only those of European descent and through the 13th Amendment, African Americans born here are entitled to citizenship. And that's the basis, the state of the law in 1923 in a segregated society for that decision. And it was used here in Florida in 2023, which is just astounding. I want to thank you so much, Bethany. I want to turn over to Margaret, but to continue this conversation, Bethany had talked about how these alien land laws violate equal protection as well as the Fair Housing Act. How does the FHA, the Fair Housing Act, operate here? What's it supposed to do when states attempt to restrict certain real estate transactions? Margaret.
Excellent. I want to thank Bethany for refreshing my memory of constitutional law, which is very relevant. The Chen case, if anyone wants it, I read it. It's amazing to understand what's going on here, and it doesn't do it justice that Bethany had to do this in 10 minutes. So please feel free to reach out to me and I will send you a copy of this case to read about it because you'll be hearing more on appeal. The Federal Fair Housing Act. So I'm going to talk about that. If any of you have taken my New York City DEI and real estate CLEs the last 3 years, you've heard me talk about what I'll talk about the Federal Fair Housing Act of 1968 and how it is relevant to what we do. For me, it was DEI and real estate and implicit bias and discrimination based on race. It comes back. It's 56 years old. It just celebrated its anniversary April 11th. Was signed into law from President LBJ, Lyndon Baines Johnson. I am proud I'm a baby boomer. I'm old enough to remember this. Many of you are not. And it was signed on April 11, 1968, as the Civil Rights Act of 1968 with Title 8, the Fair Housing Act specifically. In response, pretty much what got LBJ to move it forward was the assassination of Dr. Martin Luther King, who was really trying to fight hard for fair housing. And the president decided this was a response that he needed to put it into action. It was Vietnam War was ending. Afro-American Hispanic military men were coming back. They wanted them to have access to reasonable and fair housing. They didn't want discrimination or based on race or national origin. I say race and national origin because I'll talk about that in a little bit. All right. What this is important, this particular federal law from 1964 has 7 protected classes, which kind of goes side by side every time I talk about diversity, equity, inclusion. 7 protected classes are race, color, national origin, religion, sex, family status, and disability. I'll keep referencing the 7 protected classes. What's interesting when you come into New York and New York City, all right, so we have to be presided by federal law, as Bethany had mentioned, when you talk about which comes first by preemption, and the state and the local, and I talk about 2 comprehensively when I cover the whole 50 minutes of fair housing. In New York State, the governors, the last 2 governors have even enhanced those classes and added creed, age, sexual orientation, marital status, military status. In New York City, even more. So we take this seriously locally, and interesting that we're talking about other states in our country, but in New York City and New York State, in New York City, extended to gender, citizenship status, partnership status, gender identity, occupation, and source of income. So on a local level, we have enhanced the definition of the protected classes. What enforces, the Federal Fair Housing Act. It's interesting. I make remarks that, 15 years ago at ARIA, Hope is here, I was working with the regional directors of HUD on many programs. I never really knew what HUD was. I professed to my naivete about it. HUD is the enforcement agency put into law that enforces the Federal Fair Housing Act. If the grievances are coming forth in violation of it, it goes to HUD. If it's going to be prosecuted, it goes to Department of Justice. So there are 2 federal agencies overseeing the Fair Housing Act. A couple of years ago, they had over 7,000 complaints alleging discrimination based on 1 or more of the 7 protected classes. I just quoted disability and race are the highest complaints. All right. What covers the Fair Housing Act? It's interesting what I'm going to talk about in my conversation right now. It is residential. It covers housing, but it could cover a commercial property that has rental of apartments or condominiums. All right. What it doesn't cover, it does not cover houses. If you're a single residence, family, owner occupied buildings with no more than 4 units, single family houses sold or rented by the owner, no realtor involved, and housing operated by religious organizations and private clubs that limit occupancy to members only. The Fair Housing Act does not apply to that. But as Bethany was speaking, I wrote down on my little legal pad these remarks: ambiguous, broad language, vague, and overreaching. So as we talk about the Fair Housing Act and its application to the alien laws, I'll talk a little bit more about the issues that are coming up. Even though it is supposedly only residential, it does affect the far-reaching elements of the 7 protected classes on race and national origin. What I came up and I was excited. So Edgar and I have been texting and talking a lot over the course of planning this. I came up with a joint statement from 2016 from both HUD and the Department of Justice, Civil Rights Division, to reinforce that the Fair Housing Act has priority over state and local land use laws and zoning. And the priority is the Fair Housing Act. Okay, so the regulation of land use and zoning is traditionally reserved to state and local governments, except, and this is in the memo, to the extent that it conflicts with requirements imposed by the Fair Housing Act or other federal laws. Okay, so what happens is, and Bethany talked about that, as established by the Supremacy Clause of the U.S. Constitution, federal laws such as the Fair Housing Act take precedence over conflicting state and local laws. All right, so I'm kind of reading into it, but the way the way that they're reciting particular restrictions, you probably can read into it with careful backup that the Fair Housing Act really has. There are many law reviews on this, has been violated. It denies access to housing because of violation of the 7 protected classes. You'll keep me saying it specifically because I'm talking about the alien laws as national origin and racism. Okay, it is not. So here is a clear violation of a state and local land use and zoning law in this memo, imposing restrictions on housing because of alleged public safety concerns that are based on stereotypes about the residents or anticipated residents in a protected class, based on the belief that persons of particular protected class are more likely to engage in criminal activity. Sound familiar? Why we don't want Chinese people going by military bases. More to come as I'm reading here. Okay. We talk about intentional discrimination that violates the Fair Housing Act, which results in disparate treatment. So when I talk about implicit bias, this disparate treatment means that you're treating people differently. I always talk about equity when I talk about DEI. There is no really a land use or zoning practice may be intentionally discriminatory. And this is what it says in the memo, even if no personal bias or animus on the part of the individual government. So there's kind of a clear notion that you just can't discriminate, intentional or not. It's taken seriously under the Fair Housing Act. Okay. Even absent discriminatory intent, state or local governments may be liable under the act for any land use or zoning law or practice that has an unjustified discriminatory effect because of a protected characteristic. Again, going back to talking about how to protect those 7 classes. All right. And as we read more, and as Bethany in her brief time had talked about the Chen v. Simpson case, what we're talking about here is really not saying that it's a non-citizen, but more going to national origin, that we're going to Chinese people because of their physical characteristics, stereotypes, assumptions that Chinese people are not good to the community. So this is where we're delving into racism and other protected classes that violate the Fair Housing Act.
Yeah, in fact, Margaret, it's treating any ordinary Chinese citizen
Mm-hmm.
same as a Chinese Communist Party official or state-owned
Yes.
enterprise, and it basically ascribes to that ordinary individual the characteristics of their government based on it is either national origin presentation or at least some sort of bias there. It seems like.
You know, and on another note, I took a HUD memo. All right, immigration status and housing. So immigration status. Does it affect a person to be covered by the Fair Housing Act? No, every person in the United States is protected, even if you're an immigrant. You can't, when you're renting, the realtor's renting, can't ask, are you an immigrant? Okay. And that brings up, you know, the act prohibits discrimination, sale, rental, financing, and other housing related based on race, color, national, the 7 protected classes. So, you know, they asked the question, does the Fair Housing Act apply in my town, city, or state, even if there's a local law that does not provide, if there's no local law talking about it, the FHA presides, or that's a given. So here we go, national origin. Now, you've heard me say it many times, and I'm just going to spell it out. National origin discrimination, which prevails highly over these alien laws, is different treatment in housing because of a person's ancestry, ethnicity, birthplace, culture, or language, and it is illegal. This means people cannot be denied housing opportunities. Okay, I could read on and on, but you see where I'm going. That this and many law reviews, the Fair Housing has great relevance and enforcement of it, although it's residential. Okay, and I've read many articles. It kind of what they're doing in Florida is really kind of crossing the fine line. And I'm just going to bring up a couple of last things, and it's really showing, and you'll see some of them were really scathing, that it does violate, you know, the Fair Housing Act. It is discrimination based on national origin, not on grounds of citizenship. What Bethany raised is absolutely true. They talk about Jacksonville, Florida. I have many of my Chinese friends that relocated for corporate to be in Jacksonville. Jacksonville has about 3,800 acres of military bases. So if you can't live near a military base, you want to go down there and call the realtor, you can't, because anywhere you go, it's going to be within access, it's going to be by a military, and that deprives it of at least 2,800 residential homes. That's depriving you of housing. What if you had to, like my friends are at JP Morgan Chase, they're Fidelity Title, American Express. What if you had to go down there and you're required to live in Jacksonville? So you're saying you can't get a house because of the alien law?
And
doesn't make sense.
And you can't live on the Everglades either.
Oh, that's right. Unless you want to live with the gators. Yes.
Yeah, exactly.
Absolutely. Yes.
Okay.
And the last thing I'm going to say, she is absolutely correct. The penalties for Chinese are really high, and that's not equitable. That's not right. Okay, next. Thank you.
Margaret, I want to talk about, I want to shift now to talk about some practical implications. We've heard about the supremacy clause here. We've talked about equal protection, the Fair Housing Act, and now let's see how those legal concepts actually play out in practice. Hope. The National Association of Realtors recently filed some public comments for a proposed Treasury rule where they stated their concern that state restrictions on foreign land purchases put, quote, real estate professions in the position to enforce state laws that exclude classes of persons based on national origin, and that, quote, real estate agents risk violating the FHA, the Fair Housing Act that we've heard so much about. Hope, can you tell us how members of AREA, your members, your constituents here, many of whom serve the Asian American community and Asian clients, how these laws have impacted your members and what concerns they've raised to you?
Yeah, thank you, Edgar, and thank you, Margaret, for the invitation. I'll talk a little bit briefly about what and who AREA is. just for really the sake of some people who may not be familiar with ARIA. So ARIA is the Asian Real Estate Association of America. We have been in existence for the last 21 years, and the mission and vision of the organization is to move the needle of home ownership for the Asian American, Native Hawaiian, and Pacific Islander community. And throughout its 21-year history, we've seen home ownership grow. When ARIA was first started, home ownership was between 54%. Our home ownership rate now is about 62%. And while ARIA can take full credit of that growth, I think the work that we do certainly contributes to the rising number of Asian American, Native Hawaiian, and Pacific Islander communities. So that is the history of ARIA. And I'll kind of like talk a little bit about just discrimination regarding housing. And Margaret, you have so eloquently talked about the Federal Fair Housing Act. It's interesting because this SB 264 and other state laws that are being passed in, I think, 30 other states is probably something that we've seen as part of discrimination in housing against Asian Americans, probably much more heightened during the onset of COVID. And I think a lot of us have heard that hate crimes against Asian Americans have been on the increase in 2020. The rhetoric against Asian Americans being blamed about the COVID virus have just unfortunately been perpetuated by the previous administration, right? Calling it the Kung flu virus and all of that stuff. So we at ARIA actually have looked at, well, what is the implication of hate crimes and housing? And so in 2021, we actually embarked on a survey. And we had asked prospective home buyers and also recent home buyers on choices they've made regarding housing and location. And interestingly enough, the top two or three reasons for why Asian buyers have chosen their current location, this was in 2021, 2022, was to get away from discrimination and hate crimes and really safety. So the assumptions that it's better school districts, it's newer homes, it's larger homes, it remains to be in the top 10 of reasons for why Asian Americans choose where they want to live. But it's interesting that now it really is to stay away from discrimination. So it has this whole discrimination, this whole anti-Asian hate has had a profound effect on really housing, right? Shelter. And shelter is a basic human right. But unfortunately, we've seen that in the last 4 or 5 years, that whole shelter, there's now kind of like shelter insecurity. And unfortunately, it has been exacerbated by laws like SB 264. This SB 264 actually, again, rewinding to last year, and Edgar, I think you and I, and even Margaret, you and I have talked about a similar law that was going to be passed in Texas, SB 147, and we were actually notified by our chapters in Texas about a similar law, probably a lot more restrictive. Last year, about March of last year, that a law, SB 147, was trying to be passed in Texas legislature to restrict property rights to citizens of countries that are deemed adversarial to the United States. And it's very similar to SB 264, only it does not include Syria. And so, it's great that we've seen our members and our chapters in Texas band together really quickly, mobilize their members, and we are pleased to actually report and share to everyone that SB 147 was defeated, only to actually get notice that SB 264 was passed into law in Florida, and actually was signed into law, and it became law beginning July 1st of 2023. And Edgar, as you have stated, unfortunately, it puts ARIA members or real estate professionals, real estate agents, into the position of whether they would violate the federal fair housing law or violate SB 264. And it just sets them up to just, fail and violate either one. And as Margaret had said, national origin is a protected class. And so, real estate agents shouldn't ask, well, where is your country of origin? Can I please take a look at your passport or your birth certificate? They shouldn't, but it seemingly now the law is putting agents in to that kind of like situation. And so that's where ARIA actually had made a decision. We are not a civil rights organization. We are not a social justice organization, but we found ourselves really in this discussion about how do we protect our community? How do we protect our members? And so it was almost a 6 months to 12 months discussion on what we would do and how would we respond to protect and to continue the mission and vision of ARIA regarding SB 264. So in May of this year, last May, we made the announcement that we would file a lawsuit together with the National Fair Housing Alliance and with 2 other fair housing groups in Florida that we would take action against SB 264 because we feel strongly that it violates the Federal Fair Housing Act. Right. I'll give a little bit of history too about our founders at ARIA, John Wong and Allan Okamoto, both from San Francisco. They have been part of organized real estate, whether it's National Association of Realtors or their local and state realtor organizations. And if you talk to them, and I'm hoping that some of you I will be seeing in Las Vegas for a national convention, both take this very personally. John is Chinese American, and his parents were separated for about 18 years because of the Chinese Exclusionary Act. Allan Okamoto was born in an internment camp. So they take this personally and really don't want discrimination to happen again to this generation, right? They've experienced it personally. And are we rewinding? Are we now going back 80 years ago when, on the basis of national security, Japanese Americans were sent into internment camps? And this is what's happening. Under the guise of national security, these alien land laws are being passed.
It's so interesting that there are people still with us today who have those linkages to those historical events like the Chinese Exclusion Act, Japanese incarceration, and within living memory, right? For some, it's a generation back, but they can still remember. It sounds to me, I'm really surprised to hear that the sort of flight from discrimination is a sort of a factor here in determining where people live. And it sounds to me that it's not just, as you said, it's not a civil rights issue, but that affects the market, right? That's a factor in the real estate market. And that's something I've just learned on this call today, that this is so multifaceted. It's about constitutional law. It's about foreign relations. It's about immigration. It's about federal preemption. But it's also about the market. It's also about the economics here. And it also seems to me like you're saying that your members they don't know what to do. They're between a rock and a hard place in terms of complying with which laws. It should be federal preemption should give them a guide, but they're just, Hope, would you say they're put in a pretty uncomfortable position?
They are, right? Again, it's either they violate the SB 264 law, state law in Florida, or they violate the Federal Fair Housing Act. And unfortunately, there are stiff penalties if they violate SB 264, right? They can be penalized anywhere, I think, from $2,000 up to $15,000. And who wants that penalty? And so it seems like real estate agents, whether they're ARIA members or non-ARIA members, are put into the position of being immigration agents as well, right? And taking a look at what their status is in this country.
Right.
And I'll talk about kind of like the implications of also the market and choices to live. If you take a look at data on migration patterns of Asian Americans, while we typically are a bi-coastal community, right? Historically, we live in areas like San Francisco. I'm in San Diego, LA, and different coasts like New York, Washington, DC. The movement over the last 10 or 20 years really is in the middle of the country.
Right.
And a big part of that is affordability. But there's also now this whole, well, if I live in a less in a place where I'm going to face discrimination, should I live in areas like this where I'm not welcomed, where I don't feel that sense of belonging?
No, that's such an incredibly powerful point, Hope. And again, that's an economic factor here as well. I want to pivot over to Allan to talk a little bit more about the markets and the climate here. Allan, you represent financial institutions and project sponsors in financing real estate transaction and construction projects. We heard from Hope that where you feel welcome, can drive the market here. What are some of the risks involved for your clients here with that are posed by these alien land laws?
Thanks, Edgar. First, I want to just thank you for inviting a commercial real estate attorney to talk about a constitutional and civil rights issue. But the vast experience that we're running into with our financial institution clients is just the pure uncertainty of these alien land laws. Most of our practice has been to survey the 32 states, but it's particularly focused on Florida. And most of my comments are going to be focused more on the commercial side of the equation. The key uncertainty is location, location, location. We have no idea how to advise clients as to what properties would be affected simply because of the uncertainty of the Florida law. It's not just military institutions, it's also critical infrastructure. That center of the radius can change at any moment depending upon what would be considered a critical infrastructure. So the key in commercial real estate attorneys, we deal with legal descriptions, blocks and lots. We don't deal with radius. So if a radius should shift, does it cut a property in half? Does it cut off beneficial use of an easement? The main problem with these alien land laws has been just the pure uncertainty as to which property would be impacted by it. Another issue would be who's affected by this. Keep in mind, from a lender's perspective, we already have OFAC, Know Your Customer requirements, CFIUS compliance, Corporate Transparency Act at the federal level. Now you have to dig down to each 32 states to look at the state compliance with their state alien land laws. That's just going to create chaos in compliance departments because not all 32 states are uniform. And no offense to anybody from Florida, the Florida Department of Commerce is not prepared to address this compliance with the Florida alien land law statutes. It also forces both buyers, sellers, lenders, and brokers and title companies to do that level of KYC analysis that lenders usually have to go through, because the Florida statute is drafted in a way to impact, particularly for those from China, on controlling interests without defining what a controlling interest is. Is that 10%? Is that 20%? Is that influence on management and control? It just creates a real chaos on how to comply with this. The penalties, as Hope has mentioned and others have mentioned, there's criminal penalties, there's civil penalties. Worse, there's forfeiture. So, to try to comply with these state level laws is just going to create chaos. Of course, when I'm representing a lender or a buyer, I'm going to try to shift this responsibility to the title company. But my colleague Jim is going to tell me no way. So the message to take from this is that it will is creating chaos, and loan documents are changing, purchase and sale agreements are changing. A recent purchase and sales transaction we're just negotiating in Miami, the response to the seller was mind your own business. So it's taking some education, and it's going to be a while before we could sort this out.
And I don't want any of the 89 people leaving the room until AmTrust Title speaks about the underwriting and title effect of the alien. It's very important. Please don't leave yet. Okay, Edgar, I turn it back to you.
And
I should have held Ashley off.
Allan, you set this up nicely to pivot to Jim. But before we do that, I do have a question. Like, if you're looking at a REIT or some other investment project, and there is some Chinese investor, behind that, are we gonna have to like investigate and unwind everything, or like do divestment here and do a look back? It sounds to me that would be completely overwhelming. And again, chaos is the word you used.
The Florida statute does have a provision for publicly traded REITs, so you might be able to find a safe harbor within that existing statute. What it really impacts is the non-public REITs and what happens when the ownership changes. And so I think it's going to force particularly lenders to constantly, on a yearly basis, require their borrower to update not just certificates of beneficial ownership for the federal level, but to also do its own diligence to comply with the state statute. And that might require updated org charts, new affidavits. It's going to create a lot of work. Even the Florida affidavit that they just published, it's not a safe harbor, because it can be defeated by, if you have any actual knowledge that the borrower, the seller, the buyer is in violation of the Florida law.
Right.
Again, I look to Jim for an endorsement to insure me against this risk, but I don't think the title company.
Before Jim speaks, I want to, again, the title companies and we have title agents, we have underwriter counsels on here. We have Alta on this call. We're here to help you. So I think about all the resi deals that we have to worry about, fraud and money laundering and all of that. It's now going to go, I guess, Allan, onto the commercial. So as attorneys, we're going to do it, but we're going to help each other. Okay, we got to. It's going to be a lot of regulation and a lot of this that you can't. And at the end of the day, and we have Jim at the end of the day, the title company, we say, does not want to be on the hook. We will insure your $300 million in Brickell, but we want to be cautious and make sure. So, Edgar, I turn it to you, and I hope Jim is still here with us.
That's a perfect segue to Jim, because Allan identified this an issue that state legislatures have identified. In doing these KYC, know your customer, and the due diligence part, they said that we heard some state legislatures in states whose names I won't mention, but whose initials are Louisiana, say, "Oh, you know what? Let the title folks do this. They are doing searches. They can do all of this stuff." And the title folks, that industry down there, pushed back strongly on this. They've testified that they are concerned about chilling effects here and confusion. And so with that, I'll ask Jim, what are some of the risks here when legislatures or other parts of the parties in the transaction are trying to foist some due diligence as to determining who is a foreign adversary onto the title companies and onto the underwriters? Jim.
Thank you, Edgar. That is, in fact, the greatest risk, I think, currently under these laws. Because the laws vary greatly from state to state, you have to look at each state's laws to see the various implications, but I really look at three different areas. The first is, does it create any new duties for the title agent, the closing agent, or the title insurance company? The second area is, does it affect the title or vesting of title? In some states, the prohibited party is merely a disqualified buyer, not a void transaction. So that could lead to either divestment or forfeiture potentially. And then the third question is, does the statute address whether the buyer's status affect title or title insurance? And I happen to live in Florida, and under the Florida statute, it specifically says that this law does not affect title or title insurance, which is fantastic, but I don't think it's exactly accurate, because as we've alluded to, what's going to happen is the lenders are going to start pushing back and pushing off some of these duties to the real estate agents, to the closing agent, to the title agent, to the closing attorney, and the title insurance company. But what we really have to look at from the title insurance perspective is, are any of these risks covered? Are any of them excluded? And do we need any specific endorsements or requirements to address these concerns? Forgive my IT skills. I'll share my PowerPoint with you guys. Let's see.
While we're waiting, that's what we heard in testimony in various state legislatures, that folks from the land title associations in those states are just saying maybe the fastest thing to do, the easiest thing to do is just say, we're not going to provide coverage here.
I'm sure that many agents would take that approach, that they would just simply not want to underwrite these transactions, which would be the ultimate in the chilling effect.
Right.
I can speak from here in Florida while my PowerPoint
We're good,
loads.
Jim. We're on your last page, though. It's up. Yep,
On mine, it
that's
still says working on it.
Okay, nope, it's up. But it's good. Everyone can see Jim's contact info, but if you need to find him, you call me if you can't, okay?
Oh, here we go. Can you see page 2?
We got,
Aspects
we
of
got-
title insurance?
no, we've got your last page is the contact info, so it's backwards. Let's see if we can.
My apologies for that.
No, if not, you can run through it, and we do have it. If anybody wants it, we can send it to you on email in case we can't get it up. We can't get up on the screen right now. There you go. Okay,
all
we're
right.
here.
Closing protection letters?
I'm still on page 1.
Okay. Well, the areas we would look at are closing protection letters, whether these issues are a covered risk, whether they are covered by an existing exclusion, whether we want to promulgate any title commitment requirements, whether there are any existing title policy exceptions, and whether we need to be requiring any title policy endorsements. And I apologize that we're running close on time, so I'll keep my remarks short and we can share the PowerPoint. The closing protection letter is generally designed to cover 2 major issues: misconduct by the closing agent or failure to follow the lender's closing instructions. and fraud and dishonesty. So we're not really worried about the fraud and dishonesty aspect here. And typically this has the failure to follow closing instructions with regards to funds, et cetera, really has to do with the way that funds are released, the way they're handled. But I think this is the greatest risk to closing agents, title agents, closing attorneys, and the title insurance companies especially, is that lenders will use their closing instructions to push these verification duties onto the closing agent and require this to be done at closing on behalf of the lender, and that the closing agent's failure to comply with the statute, verify the buyer's status, etc., would be deemed a loss under the closing protection letter, even though it may not be covered under the policy. However, one thing to consider with the closing protection letter is there's no liability absent an actual loss by the insured. Mm-hmm. And under the closing protection letter, the title insurance company is not responsible for all acts or errors of the closing agent, only for the enumerated matters. So we're really going to have to start pushing back. Well, one, people are going to have to start reading lender closing instructions again.
That's right.
And two, if there's anything in there with regard alien land restrictions or transfers, then we're going to have to push back or object or request revised closing instructions. Because that is not going to be an acceptable requirement. With regards to the covered risks, Allan alluded earlier that some states provide for civil forfeiture of the buyer's property to the state. That is currently a covered risk, assuming that state notice requirements are satisfied. And the same also applies on the loan policy. I will note that under the Florida statute, SB 264, that there is a protection for lenders for a bona fide lien. So much like the federal civil and criminal forfeitures, bona fide liens are honored in the forfeiture process, and they are protected to the extent of value in the collateral. Exclusions from coverage under the owner's policy. Of course, anything created, suffered, assumed, or agreed to by the insured, or not known to the company, but known to the insured. So, of course, for the owner, the buyer, they would know their status, and we would deny a claim based on that standard exclusion, which is in the jacket. And I cite the exclusion number 3 from the jacket in my notes. Under the lender's title policy, the similar exclusions, but here it also adds resulting in no loss or damage to the insured. And again, if this lender's bona fide lien is protected under state law, then there would be no loss under the policy. There's a slight rub here in that because the laws do vary by state, it will fall to the title agent, the closing agent, or the closing attorney to review the state statute to see if the state law provides for forfeiture of the property and if it protects lien holders' bona fide liens. I've also cited the policy there. Where state law restricts ownership of land based on status, notice should be provided to all parties regarding any state restrictions regarding buyer status, and buyers should furnish a sworn statement to the closing agent, title agent, or closing attorney attesting to their status. Florida has promulgated through the Florida Real Estate Commission these forms to be used in Florida, and in the other states, they're a little lag time, but they will be promulgating documents that can be used in these transactions. However, as Edgar alluded to, they don't exactly provide a full safe harbor by relying on these affidavits. But there is a reporting duty, there is a due diligence, and I'm assuming that Alta will be adding this to their best practices at some point once the law settles out. Currently, we're not requiring any additional exceptions on the owner's policy because of the existing exceptions. No additional exception would be required. Agents will be allowed to add an exception for violation of any state-specific statute if they feel that's appropriate, but we have not issued any bulletins requiring that or added that to our underwriting manual. However, it's important to note that no affirmative coverage may be provided over a violation of these state statutes, even where buyers furnish the requisite proof, affidavits, or forms, even those forms promulgated by state law. So under no circumstances should the exceptions be removed through affirmative coverage. Under the loan policy, lenders should be protected. In states where bona fide liens are specifically protected by law, in the event of civil forfeiture, there may be occasions where the lenders might ask for the Alta 34 or 34.1 with regards to an identified risk, which is available only for the loan policy, or they may ask for a blank endorsement in states where the 34 and 34.1 have not been approved for use. Those would require underwriter approval when requested. In states where bona fide liens are not specifically protected, no endorsement may be issued without prior underwriter approval, and no standard exclusions may be deleted by endorsement. In where these endorsements are required, it's possible that there may be a high risk premium that would be required given the nature of the transaction. Under the loan policy exceptions, the remedy is typically divestment or forfeiture. And again, we went over the protection of the mortgage status. In general, the lawyerly answer is it depends based on the state's various states' requirements and impact on title and title policies. The real risk is in due diligence, where the lenders most likely will be trying to offload their duty to confirm their borrower status to the closing agent, closing attorney, or even title insurance company. And no doubt they will try to shift the liability to the title insurance company under the closing protection letter or the policy where available. So the parties should be on lookout for those requirements in their closing instructions.
Jim, thank you so much. I know we have a lot of New York agents I'm looking through that probably do Florida work. So please feel free to reach out to AmTrust, specifically Jim, who is venued in Florida. Again, this is all so new, but be aware of what we're saying, the due diligence and all of the ramifications. There'll be updates as things go along. But, please feel free to reach out to us. I see we're at 12:18. I wanted to thank everybody for attending. We will have part 2. Look out for it and contact me. And I want to turn it over to Edgar to say his last parting words. Thanks, Edgar. Here you go.
This has been incredible. This has covered so much ground. and again, this is just for issue spotting. I mean, I've got a ton of questions for Jim about encumbrances and
Yes.
stuff like property law and are these racial
and what do we say, restrictive covenants, all the good juicy underwriting stuff.
Restrictive covenants and how do you recognize that? I mean, we're going to do this in part 2, as Margaret said, but I want to thank all of our wonderful panelists today: Bethany, Hope, Allan, Margaret, Jim. A thank you to AmTrust. Thank you to Aria, to Aldef, Parkins, Coie, for making you available, Allan.
And NAPABA. Thank you to NAPABA.
For making this possible. Again, there's so much to unpack. We need to do a series of this because each topic in and of itself is worthy of its own CLE. And we're already, Margaret, you and I will start working on the next one.
Absolutely. Absolutely. Happy to do so. Thank you, everybody. Have a great day. Thank you for coming. Bye-bye now.
Thank you.